Hello and welcome to this special CNBC TV 18 broadcast. I'm Ashmit Kumar. Don't make the honest suffer. Now, with these observations, the Supreme Court bench, comprising of none other than the Chief Justice of India, has asked the government and the RBI to ponder some relief for some people who still hold old 500 and 1,000 rupee notes. Now, the court has given 2 weeks' time to the government as well as to the central bank to consider options to provide a window for such individuals to deposit old 500 and 1,000 rupee notes. Now, remember, earlier this year, in the month of April, the centre had clarified its position and informed the Apex Court that it had taken a conscious decision of not extending the window beyond the 30th of December last year for exchanging old notes, unlike for NRIs and security personnel posted in remote areas, which ended on 31st of March. Now, over the next 30 minutes, we will discuss under what context the judges made the observations today. Former Additional Solicitor General of India, Vikas Singh, and Senior Supreme Court Advocate Mr. Sanjay Hegde will be joining us to share their thoughts and perspectives on these observations coming in from the Apex Court. Gentlemen, appreciate you joining us this evening on this, let's say, sensitive issue. Mr. Hegde, to you first. Your first thoughts. The Apex Court is of the clear opinion that the government has erred, at least as far as allowing the window is concerned. The Apex Court seeking to draw the attention of the government on genuine bona fide cases. Your first thoughts.
Well, first thoughts are that there are always going to be genuine cases. And if a genuine case finds no other window, it comes to the Supreme Court. I have been in the Chief Justice's court often, and I've often seen these matters come up before the Chief Justice. The Chief Justice has tried to, in certain cases where he saw no merit, he dismissed them. But there were cases which were hard cases, and they were recurring. So it's obvious that the message has gone home that there are people who genuinely could not get through the deadlines to deposit notes, and that the reasons were nothing to do with tax evasion. So he's asked the government if there is a way out, and this is nothing unusual. There have been instances also earlier where the court has asked the government, can't you find an administrative solution, or do you need us to find a legal solution?
Fair enough. We'll delve into the contours of the problem at hand in just a bit. But first, let's look at the conventional debate which usually surrounds such issues. This is, at the end of the day, an economic decision, an economic policy move that has been made by the government, the legislature, the ordinance vetted by the parliament as well. Just to play the devil's advocate here, given that this falls squarely in the domain of economic policy making, is there room for the judiciary to intervene and to perhaps push the government into making some decisions?
Well, economic policy of demonetization, there are a whole batch of petitions which are pending before the Supreme Court which challenged it. That basic decision, that basic challenge, it has gone to a constitution bench. We do not expect it to be heard in any reasonable time to make it actually meaningful, or there can never be a rolling back of demonetization. In the implementation of the policy, if there are angularities, the court has two options. Either it can say, look, I can do nothing, or the court can look into it to some extent to see whether some of the angularities can be ironed out, if not by it, but at least by a willing government. So it has asked the government, look into it, come back and tell us why, in good reason, you cannot make a few exceptions. More particularly so when more than 99% of the money has all come in. This remaining 1% or 0.5%, and out of that, if there are genuine hard cases, see what you can do about it.
Right, look at genuine cases. That's broadly the sum and substance here. Also joining us, of course, is Senior Advocate Mr. Vikas Singh. Sir, to you now. Let's just first look at from where the genesis of the issue at hand. The petitions before the Apex Court are quite clear in pointing out that the Prime Minister's speech on November 8th, as well as the notification which came only hours later, created a sense of legitimate expectation, a sense of predictability and certainty was created by way of that speech and that notification, and that is where the government erred. Just your sense, was there a fair and legitimate expectation on part of the citizens in assuming that there is a window that will remain open till 31st of March 2017?
Well, if you ask me, there are two aspects of this decision which was taken on demonetization. One is a decision which is directly relatable to the economy, benefit to the economy, that all the black money, all the money which is there in the system should come back into the system, and in that sense, overnight, at least on a particular day, every cash that is available in the market will become white. And thereafter, if you have to withdraw again, then you'll have to create again black money, and then black money will have to be regenerated. So that was one important perspective, which was a very good perspective, which was a very good basis for the decision. The second was that if there is fake currency floating in the system, then that will automatically get eliminated. These were the two large basic objectives on which this policy was formed. If these two are to be taken as the basis for the policy, then there was no reason for the government to say that overnight this money has become not legal tender. There was no reason for the government to say that after a particular date, happen what may, we will not accept this money as a valid tender. The only reason for doing that this money will not be valid tender was political, and that was the hidden reason, which I feel was that there was these two state elections, these couple of state elections coming, and the government had a political agenda of ensuring that the black money which is circulating with the political parties, that should, sort of be, you should frighten them that that money is of no use and they can't use it in the election.
Right,
so
Mr.
that
Singh.
actually created
So there
all
was,
the problems.
you believe,
that
a
really
sense of
created.
Right, so a sense of legitimate expectations that were created. Mr. Hegde, if I can come to you on the legal sanctity of the legitimate expectation that was created. There was an argument forwarded by the Attorney General as well as the Solicitor General before the Apex Court that is, despite the speech having been made, the ordinance will enjoy greater legal sanctity. So just a question to you now, given the sense of the air of legitimate expectation created, what does that do as far as legal sanctity of the speech and the notification vis-a-vis the ordinance that we saw in December of that year?
Well, if you ask me strictly in terms of law, a speech has no legal sanctity, even if it be the speech of the Prime Minister. Ultimately, what works is the legislation which is passed through Parliament, as well as any official notification. But legitimate expectation as a doctrine in administrative law has come in to basically become a facet of fairness. If there is a government policy set out by the highest minister in the land, government is expected to conform to that policy and not deviate from it without good reason. A court is entitled to ask what is the reason that after setting out to do something, you deviated from that, and as a consequence of those deviations, people who were at the receiving end unnecessarily got hurt. If the deviation is seen as unfair and violative of legitimate expectation, in some rare cases, courts have intervened. Currently, we are not looking at the law. We are just looking at an administrative solution, and the court is asking the administration, do you, given the nature of the problem, have an administrative fix or do you not?
Fair enough. So that deviation in stance, importantly, needs to be explained. But again, to go back to the arguments of the Attorney General as well as the Solicitor General, in their arguments, as far as their perception is concerned, there has been no deviation. And for that, they cite the language of the notification, which, as per them, says that there shall be an opportunity to do so, which is to do so would mean to deposit the notes at specified offices of the RBI or such facilities under a later date as may be specified by it. And that last clause where it says a later date as may be specified by it is being used as a caveat by the government, saying that there was always the freedom to go ahead and to tweak the dates as and how and when they see fit. Mr. Vikas, if I can have your thoughts, the language of the notification, does that allow room for the government to perhaps explain the deviation from their initial position as on November 8th?
Well, if you ask me, if you go by the larger economic benefit to the nation, there is no reason why the money should not be accepted up to a particular date and it should remain valid tender till that date. And if after that date, if also somebody has some money which he can explain was bona fide not available to him for exchange. Like for instance, somebody's money lying in the locker and that person dies and legal heirs find that money in the locker after his death. Now they can always explain all this and give the money back to the Reserve Bank of India and explain that during the period, the window that was open, we didn't have access to this money and accordingly we couldn't give it back. So all that should definitely be allowed. I don't see any reason why the government should not issue an amendment notification and permit such kind of money to be taken in. And if the government is not forthcoming on this, then the court definitely has the duty to intervene in such matters, because after all, it's right to property.
Mr. Hegde, if I can just play the devil's advocate once again, in the sense that there was a reference made by Mr. Vikas with respect to the economic rationale. Speaking of the economic rationale, given the scale of the decision involved here, isn't there a certain amount of collateral damage that perhaps we were to anticipate, to expect with an exercise of this scale?
Well, you've used the right word, scale. If you look at a macro level, the decision has gone ahead and thereafter the courts have not interfered with the macro decision as yet. The rationale of the macro decision still has to be explained to courts, and courts may, the Constitution bench of the Supreme Court, as and when it meets on this issue and as a hearing, may come out with a judgment. But when you take macro decisions at a micro level, on the ground level, people might get hurt. Individuals will get hurt. And in our constitutional scheme, every individual has a fundamental right to approach a court, including the Supreme Court. That is not a right which the government can take away or waive. So we have had this situation where many individuals have come to the court saying, look, I have been a law-abiding citizen. I have done everything that was possible within the law to do, but yet I could not legally adhere to the deadline which the government has set out, and therefore, please, Mr. Supreme Court or High Court, I am entitled to come to you for relief. The courts can in such an instance, consider the facts of the case and as a matter of law also rule that these kind of situations, the government has to accept the money and the currency and provide fresh currency. But before you go to a ruling, before you go into questions of law,
what perhaps you're hinting at, a balance between the economic rationale as well as the personal rights. Right, so that's the sense that we're being left with, that a need is being felt to have a sense of some semblance of balance between the two sides, the economic rationale and the individual rights here. On that note, let's head into a small break. We'll be back when we'll continue this conversation with Mr. Vikas Singh and Mr. Sanjay Hegde on the other side of this short break. Keep watching.